And thank you for staying with us here on PM Express. So now we're going to have a conversation about the Freedom of Information Law, pricing a human right. If you've not heard, there are institutions of state who are placing a hefty price on enjoying this fundamental human rights. And so we say, is this elusive? We struggled for years, decades to pass this law. Now it's enforced, and it's thrown up several challenges in implementation. So that's why tonight we want to have this conversation. Let's look at what the issues have been since it happened. One of the key things that has happened, in essence, is that several institutions have praised a significant price on information they are giving out to the public. The West African Media Foundation, the Media Foundation of West Africa, had gone, for example, to seek information from the Communications Ministry. And the Communications Ministry had placed a price on that, about 2,000 CDs, and they went to court. But there's a landmark decision on the back of that had triggered this conversation. Just last week, the court decided that indeed the price should hold, but they slashed it down from 2,000 to 1,500. We'll look at that. Also, as we see, the Media Foundation, the application they had put forward requested information from the NCA on the radio stations that had been closed. Then there was also, still on the Media Foundation for West Africa, the story of the Fourth Estate, also writing to the Minerals Commission. The Minerals Commission also then placed, guess what, $1,000 price on the information that the Fourth Estate was asking for. Now, that $1,000 amounts to something almost 6,000 CDs, indeed, which is a quite hefty price to pay for accessing a fundamental human right. I mean, that is yet to be litigated, but the fundamental court decision raises several issues indeed. The Media Foundation's court case was simply on the fact that the application to the NCA and the price they had placed on it was unlawful, unreasonable, unfair, because the law doesn't also specify how much exactly, or just to say that there's a price for that the institutions can place on it. The challenge with that, as we've heard, is that the Parliament itself must be giving a certain LI that will spell out the fees and charges. Has that happened? So far as we know, that hasn't happened. And so all these agencies are imposing their own fees on it. Very extortionate, very prohibitive. That may defeat the purpose of this law, because it's supposed to be for everybody to access. Not only journalists, by the way. Not only journalists and institutions like Media Foundation. Media Foundation can afford, I've heard some of you say about 2,000 CDs Media Foundation should be able to afford. It's not about whether they can afford or not. It's about the principle. Because this is a fundamental human right. If you have to pay to enjoy that right, that prices a whole group of people out of enjoying the right. And that is why we're going to have this conversation today on the back of this. I'm going to be putting together those who understand this law. They participated in the drafting of it. It's been, what, a year on since the actual implementation started. It's good to pause and analyze and sort of do a certain analysis of the implementation so far. How has it been? What are the challenges? Is the Freedom of Information Commission working? The information officers, are they in place? The law also specifies what the agencies must do, putting together what they call a certain guideline, a certain manual to guide the entire institution in terms of access to information. I wonder whether the institutions have done so. You want to stay with me as we begin to delve into this matter quite closely. I'm quite interested in this conversation because of all the noise, the campaign, the agitation, the protest that went into giving birth to this law. Now we have it, and it's all challenges, as we've heard so far, from those who try to apply and access information. So stay with me. We're going to get into that here when my guests get seated. Thank you very much for joining us here on PM Express. My guest who are joining me right now is Sam George, and Sam George is a ranking, deputy ranking on the Communications Committee of Parliament, MP for Ningo Prampram. I'm grateful, Sam, for your time here on PM Express.
Thank you very much.
Dr. Kojo Asante is with the Center for Democratic Development, also joins us via Zoom. He is the Director for Advocacy and Policy Engagement at the CDD. Manasseh Azuri-Awone is a freelance journalist, also works with the Fourth Estate. Manasseh, to be very specific, correct? Manasseh, please unmute. Please unmute.
No, very good save. I think we sit with a bit of disappointment.
Manasseh, please unmute.
Said.
Okay, great. I can hear you now. Yes.
Okay.
Suleiman Abrama is with the executive director of the Media Foundation for West Africa as well. And later, we'll be joined by the Information Ministry's head of access, and they had, of course, been if you look at the law, gives a lot of responsibility. The Ministry of Information gives a lot of responsibility to them in terms of ensuring that aspects of the law that requires an ally, indeed, together with the commission, is brought forth. We speak to Winifred Nafisa Mahama, doctor, who is the head of access to information division at the Information Services Department, later on in the conversation. Let me start with you, Manasseh. You at Forte State had recently also written to the Minerals Commission, and they placed a $1,000 price tag on accessing that information. And you've written to them with a protest on this. I know they've written back to say they're using internal processes to make that, to determine that price. Are you going to go forward and make that payment of the $1,000?
Obviously, no. I think it is ridiculous for anybody to expect us to pay that amount of money to access information that is ours in the sense that we are Ghanaians. And then we have even gone ahead to petition the Rights to Information Commission. And we are hoping that in the coming days, they will sit and then listen to this matter. The Minerals Commission is making a point that has already been made by the court. It is relying on its own internal or its own laws or ally. And then the court that ruled in the case of the NCA versus the Media Foundation for West Africa made it clear that when it comes to the right to information law or request, the agencies or institutional allies do not apply in determining the price. So it is very strange that the Minerals Commission is still relying on its own ally to determine how much someone has to pay just by requesting information. And you can imagine if you're a journalist and you are doing a story, sometimes in my investigations, I reach out to a lot of institutions. For instance, contract for sale, I had to go to every state agency or ministry that awarded Talent Discovery Limited a contract to seek information. So if anybody or if all these institutions were demanding this ridiculous amount of money, then they are telling you that you have to just stop your investigation, because I don't think any media house will be able to pay that much to 10 or more state institutions or ministries just to get information to do a story.
I want to come to the court case, because I think it's so fundamental to this whole conversation. I want to bring in Suleiman Abrama, who heads the Media Foundation for West Africa. I mean, Mr. Abrama, you went to court on this, and the court pronounced because of the charge of 2,000 cedis. Some say, well, 2,000 it's small. Media Foundation should be able to afford. The court has pronounced on this matter. How fundamentally does that court pronouncement affect the enjoyment of this right that I know you and many others fought for? Do we have Suleiman Abrama?
Yes, can you hear me?
Yes, I can hear you, yes.
Yes, so I was saying that we went to court certainly not because we couldn't afford to pay 2,000, and indeed everyone knows that going to court would mean that we would spend perhaps more than 10 times of that amount of money. But we went to court as a matter of principle and in defense of not just journalists, but ordinary people who may be seeking information across the country in exercise of their fundamental rights. I think that the decision of the court certainly undermines the right to information legislation and the extent to which people can use it to seek information. Because essentially, we were asking the NCA to give us the list of radio stations they have shut down, and then the list of radio stations that are operational in the country. and the date on which these radio stations were authorized and the last date that they renewed the authorization. And something as basic as this. Surprisingly, the NCA rise back to say we have to pay 2,000. And the reason they give is that what the information we are requesting will require that they do a lot of hard work and a lot of research to be able to generate the list of radio stations that they themselves have shut down and the list of radio stations that they themselves have authorized, and then the extent to which they have renewed or otherwise. And we thought that, why would an institution that regulates the industry, you shut down radio stations and we simply say, give us the list, and then you say you have to do research to be able to get that. So we go to court, and then at the end of it, the court says, well, don't pay 2,000, instead pay 1,500, a reduction of 500. In my view, the question to ask is, what is the court saying we should pay for? That the court is saying we should pay for the time that they will spend in doing the research or the hard work that they would have to do to generate the list of radio stations that they themselves have shut down. I think this was so fundamental, and that's why it's so curious that the judge would award, that amount of money to be paid to NCA in order to access that money. I don't think that we pass the right information law so that public institutions can begin to sell information. But so far, that is what we are experiencing. So we will wait for the full judgment, and once we have that, I certainly think that we would go the next step to try and test the principle, because otherwise, if we go ahead and pay 1,500, the next day, a journalist from a local media house goes to a district assembly to say, I just want the list of contractors you work with, and then the person will be asked to come and pay 1,500 or 2,500 or whatever. And at the end of the day, the law would have been rendered useless.
So you're looking to appeal this decision?
Well, absolutely, because I think we have to really get it right. If we go on appeal and the appeal judges say, well, yes, you have to pay because Parliament has not passed a regulation yet, even though the RTI law itself says if you have to pay, if information is not exempt and you would have to pay, the cost that must be applied is the cost for reproducing that information. In other words, if I want a bulky document and you have to do photocopies for me, I should pay the cost of the photocopies. Or if I need it on a pen drive, I get it on a pen drive, and therefore I pay for the pen drive. In the case of the NCA, we actually asked them to send it to us via email. So there was not even a question of printing for you to say the cost of toner or the cost of photocopy or whatever it is. So I think that collectively as a nation, we have to keep pushing until the court, maybe if we get to the appeals court or the Supreme Court and they say, until Parliament approves the legislation, you have to keep paying, then of course we know that what we went for is a law that allows public institutions to sell information to us rather than one that allows us to access information.
Yeah, stay with me. Let me come to the Member of Parliament with me. And Sam George was part of those in Parliament when we debated this and passed it. Mr. George, is this what you anticipated when you and your colleagues worked tirelessly to get this passed? That information will be up for sale?
A very good evening to you and to our viewers and to Brahima and Manasseh. I sat in this studio in the early days of the 7th Parliament when the agitation for the Right Information Bill, as it was at the time, came up. And I made categoric statements that the media and the coalition was focusing on the wrong things, and that the Right Information Bill, if it became law, will not give journalists and Ghanaians better access to information. I was castigated. I was called all kinds of names. Today, the chickens have come home to roost. Because I looked at the structure of the law, and it was clear to me that we were basically just going to pass a law that was going to sit on the shelves of our country and say that Ghana has passed a law, but in actuality, there were no structures within the legislation to give action or life to the text of the law. You look at how government went ahead with this, and it's obvious. We passed the law into act, the act into law. We were told to give it a 1-year period for the structures to be put in place. It took almost 18 months for the structures to be put in place. This law has been passed. We are entering the 3rd year after we passed the law, and the ministry or the commission has still not been able to bring before Parliament the proposed fees and charges. And so what they've done is they've created a lacuna intentionally, and I'm saying on authority that it's intentional to create a lacuna where there's a disincentive for getting information. Now, look, in the case of the NCA and BRIMA, the Media Foundation for West Africa and the NCA, it is mind-boggling that the Media Foundation for West Africa should actually be seeking this information under the RTI. The NCA ought by the law that sets up the NCA, publish its annual reports 3 months after the expiration, after December 31st of every year. And 3 months after that period, which means by 31st of June or 30th of June of the preceding year, the minister responsible must lay such a report, an annual report, before Parliament. The annual report for the NCA for 2016 has not even come to Parliament in 2021. If you remember, the Honourable Minister for Communications was asked at her vetting, and that's a question I pushed to the vetting committee, to ask her why in 4 years as minister, not even one report, not one, has she submitted to Parliament in contravention of the law. If the NCA had submitted its annual reports of 2017, the details of radio stations that were shut down and licenses that were given, that the Media Foundation for West Africa is seeking today under the RTI, will be in that annual report. They've not done that. Now the Media Foundation goes to the NCA, and then you ask them to pay what, 2,000 for doing what you should have done and you haven't done, and then they go to court. And respectfully, I mean, with the greatest of respect to Her Ladyship Justice Gifty Ejeado, I think she doesn't understand the RTI law, because this is the second ruling she has given that, for me, flies in the face of the spirit and letter of the law. In the Ernest Nogbe versus Electoral Commission case as well, in the same instance, she in one breath said, oh, the EC must give him the information, but slapped a cost of 1,500. Does she understand the law?
So the 1,500 is something that this is the second time.
And then now Media Foundation for West Africa goes again. She slaps out, my lord, if you don't understand the law, don't rule on it. Get better education on the law. We passed the law. The law is clear that when the information is in the public interest, there shall be no cost. Look, I can read explicitly, and for the purposes of Section 75 of the RTI, says, Section 75, fees and charges of public institutions. An applicant seeking access to information under this Act shall pay the fee of charge approved by Parliament in accordance with the Fees and Charges Act 2009. So, my Lord Justice Gifty Ejeado, you have no power to fix a price.
But Parliament hasn't done that. So
yet. If Parliament has not done that, she must refer it to Parliament to take the requisite action. She does not have the power to determine the price, first and foremost. Secondly, subsection 2 of 75 says, despite subsection 1, a fee or charge shall not be payable for A, the reproduction of personal information of the applicant, B, the reproduction of personal information of a person on whose behalf an application is made, C, the reproduction of information which is in the public interest. Are we saying that the work that the Media Foundation for West Africa does is not in the public interest?
But who determines that?
Well, that is an objective test that the court should have established. Now, except she's going to establish that in all fairness to the judge, we have not seen the full report.
Yeah, that's the full judgment.
If in her judgment, she makes a determination that the work of the Media Foundation for West Africa is not a public interest job, then she will be in her right to even be ascribing the fact that they must make some payment. But if, like I believe, and the position I hold, that the Media Foundation for West Africa, except anybody can establish to us that BRIMA and his people are doing or need this information for personal gain, or for commercial gain or commercial purpose, then you'll be able to say it's a private interest. But if it is to entrench the work that they do as a civil society organization in the media space, then that's public interest. It's a subjective test, or it's an objective test you should undertake. And so, for me, I think that the judge has missed the point in this. And I would urge the Media Foundation for West Africa to go to the appeals court and establish the fact that the judge did not understand the law she was interpreting.
He's indicated that that's something they would do. Now, I want to bring in Dr. Kojo Asante with the CDD. I mean, Doc, where do you stand on this? I know you were part of the coalition that pushed for this to happen. I mean, what's your own reaction to all that has happened since this law was passed to date? Now there's been 2 court rulings, verdicts on this matter, all of them imposing fines, well, fees in the region of 1,500. And of course, then there's a Regional Commission's own case. What's your own reaction to all that?
Yeah, good evening, and good evening to your viewers. Well, I mean, the coalition, and currently I chair the coalition. We've always expected that, you know, this law, and if you look at it across the world, when an RTI law is passed, there is always going to be a tussle between the state and, you know, those of us who are trying to assert our rights. So we expected always that we were going to have these challenges, and our commitment was that we have to be ready to engage to ensure that you know, whatever the intentions of the law, they are fully implemented. So some of these challenges that are coming, we are going.
Oh, I hope I haven't logged Dr. Kojo Asante there. He's still on, okay, but we can hear him. So I don't know, he's frozen, I must believe. Hello, Doc. Okay, we'll try and get him back because he chairs the
coalition fully. And what has happened is a clear exposure, you know, exists within the state nation, and they have, as you know, ascribed to themselves all these powers that,
unfortunately,
are trying now to come. We will fight it. I think. Hello.
Yes, sorry, we lost you briefly. Yes,
yeah,
make the point. Yes.
Yes. So for me, there's a lacuna. That's fine. We just made our input into the LI for the RTI Commission to submit it, and hopefully that should be done as quickly as possible. But even if there's a lacuna, you know, Article 26 of the Constitution is very clear about the use of discretionary authority. It cannot be arbitrary, it cannot be capricious. So you can't just claim that, oh, well, for example, whatever law. The law is very clear that you cannot charge somebody for preparing the information. It's exempt. Section 75 is very clear. It actually lists you cannot impose a fee for, you know, to pay the officer that's already been paid public. So that is itself a complete, you know, they've turned the thing upside down. A lot of people don't understand. So we also have to do a lot of editing. And the law is very clear that it cannot be, you cannot charge a fee for that. So what I'm glad that Manasseh said that they have petitioned the RTI Commission. I think they should come out with, you know, a directive as quickly as possible. You have to charge reasonable fee for reproduction of the information. And this is an objective test. If it's a video that you have to reproduce or whatever, it's not difficult to find out what it costs. So I just think people are just being completely mischievous. And when the law bites, those kinds of actions, there are penalties under the law, you know, that to be dealt with. So hopefully, once we can get the fees processes done, then people cannot be misbehaving, because that is constructive denial of information.
But Dr. Asante, in the absence of the fees and charges as approved by Parliament, there is a precedent now by the High Court, which in the absence of that is the law now regarding the fees, 1,500, right?
No.
As we've seen.
It's not a precedent. I think
you disagree? Okay. Well, what is
I
it
haven't
then?
seen that.
How would you describe it then? Because it's a determined case by the High Court.
Can I come in with an example, please?
Yes, please, Manasseh, whilst we try and get...
We have written to a number of institutions and ministries.
That was to ask to...
Sorry, Mr. Asante, we'll try and re-establish connection with you properly. So Manasseh, please go on.
Yes, I was trying to say that that couldn't be a precedent because we at the Fourth Estate have written to some state institutions that have given us information free of charge. They have not taken a peswa. And I think the Judicial Service is one of them. We have written to the Ministry of Justice and Attorney General. I also know that we've got response from the Ghana Highways Authority, and they even had to photocopy a whole contract, sent it to us. And so those that have taken money for some of this, some took as low as 60 Ghana cedis, less than 100 cedis. So some institutions that understand the law are being reasonable.
Okay, others aren't being. I mean, but let me come to you, Sam George. Apart from the fees and charges conversation, when the commission came into being after the 1-year moratorium, the law also specifies several actions that state agencies must take, including the establishment of what they call these guidelines, the guidelines for accessing information. All the agencies must have that, who the information officer is, how do you access the information if you apply to them. I dare say that many of these agencies haven't complied with the law when it comes to that.
Okay, so what I know has happened is the Ministry of Information, which is the mother ministry for this RTI, has tried to centralize the recruitment of the information officers and send them out into the various agencies. That in itself has come with this bureaucratic challenge. My good friend Kojo Opon Nkrumah has tried to delegate. I've had a few conversations with him around it. He's tried to explain to me how they're working they've done certain trainings and they're looking at deployments and all of that. But the issue here is in deploying these information officers, and even for the agencies that choose to employ their own information officers, in many other jurisdictions, information officers are certified by the Data Protection Commission of that country. Because you see, you are dealing with data protection laws as well. And Ghana has one of the most robust data protection laws. And so most times the agency that handles the right to information request is the same agency responsible for data protection. So you are able to determine that the data protection rights of subjects of request are protected. Now the question I want to ask, and which exactly is a fact, is that most of these so-called information officers are not data protection certified. One. So two, you have, then the second issue that raises is that you then have instances where people are rejecting information requests, saying that it's a breach of confidentiality when they do not have the requisite training. Three, you have instances where officers or scheduled officers in these agencies decide with their chief executives to impose prohibitive charges. Like you saw the case of Fourth Estate. What they basically did, if what I've read is right, they have referred to their mother law, the Mining Act, and taking the cost of a cadastral fee, which is $500, and say you're making two requests, so that's $1,000, and given that. But the point here is, if you had an information officer who is properly trained, that information officer will notify the chief executive that this request has come and this is how we must treat it. If you read the law, the processes for how the request must be handled. And since we have Manasseh and Sulemana here, I would like to know from them who responded to them. Was it the chief executive? The chief executive is not the one to be responding. It's to be the information officer.
Let's clarify, because that is so important in terms of what the law says. Mr. Brahma, are you still on with me? Mr. Brahma, can you hear me?
Yes, I can hear you.
Yes, can you please clarify for me, because we're still going to the law to make sure that the law is being followed. That question, when you wrote to the NCA, did they have an information officer who followed the procedure as specified in the law in responding to you?
Well, so you see, Evans, in accordance with the law, every right to information request that we have made, we address it to the information officer, and we normally would say that in the absence of one, then whoever is in charge of addressing matters like that. So that was the address we sent to the NCA. The NCA did not reply within the stipulated 14 days. At that point, we were even contemplating whether we should take legal action right away. And we were advised that, well, we should just follow up as a reminder, as a matter of courtesy. Then we did that. When we did that, then 2 letters came. One was signed by the Chief Executive or the Director General, Mr. Joe Anochi, indicating that there was a particular question, I think that was item 3, where we were asking why they decided to delete from their report very key information in relation to when stations were authorized and the last time that those stations were renewed, because it is on that basis that you can establish whether a station is operating illegally, whereas others have been shut down. And as their own data proved that that is what they did, they shut certain stations down because of whatever reasons and left others with similar infractions on to operate. Then the other letter came signed by the Director of Legal, Dr. Poku Ebuse, and that was where we were being asked that in accordance with the Electronic Transactions Act, I think Section 82 or thereabout, we were supposed to pay 2,000. And in fact, in that letter, they did indicate that the request that we have made would require a lot of hard work on their part and a lot of research for them to be able to retrieve the list of stations that they had shut down and the list of stations in this country that are active and those that have been, operating without authorization. So specifically to that question, that is what happened.
Manasseh, what about you? When you did the application from Forte State to the Lands Commission, Minerals Commission, what happened?
We addressed it to the information officer, and like Sule mentioned, said in the absence of such an officer, whoever is in charge should respond. And so it was the acting chief executive officer who responded. But on the issue of who responds, we had a very interesting experience at the Ministry of Health. The law says we should address such information or request to the information officer. We did that, and at the Ministry of Health, we were shocked to learn that if we didn't address it to the minister, our letter wasn't going to be accepted. And in fact, the person who sent the letter came back to me and said, look, they wouldn't even accept it, so we had to change the address to the minister before it was accepted, and we haven't even got the information. So it appears I met with one chief director of a ministry 3 weeks ago, and he actually said, well, when we first got this request, we were actually confused. We didn't know what to do because they had taken certain steps that were obviously not in line with the law. So as to whether or not the information officers receive it, some of the institutions, I can say for a fact that if you take the Ministry of Local Government and Rural Development, we have been dealing with the information officer there. So some have, but some don't have, and others still believe that once you don't address your request to the minister or the head of the institution, you might be doing something wrong and not in accordance with the law.
Mr. George, that's your answer.
So fantastic. The point I was making here has just been established here. Now, if you read the Act, Section 19, person to deal with application. An application to access information shall be dealt with by the information officer of the public institution. Yeah. So under no circumstances should a chief executive or a minister demand that, or it be said that it must go to a chief executive or a minister. Again, because of what Suleimana said about the 14-day timeline, the Act again is specific. It says that if you do not get a response in 14 days, it is deemed that they've refused you, and you must then exercise the rights in Section 31 to 35. True. Now, Section 31 will say that you should do an appeal to the head of institution. Yeah. So the head of institution should only come in after there has been a refusal of your initial request. Yeah. So you see, that's why I said the whole architecture for the implementation of the law is so defective because you don't have information officers properly trained in the institutions, and even when you have information officers properly trained, chief executives or ministers determine that unless the request comes to them, it will not be treated. These are all things that I think we must begin to test the law on. But the judges themselves should read the law and understand the law.
On that point, I want to come back to Dr. Koji because he's a lawyer amongst us here. Doc, do I have you back on? Hello, Doc. Dr. Sante, do you have you back on?
I'm on. Can you hear me?
Yeah, I can hear you. I mean, kindly address that.
Can you hear me?
I can hear you, yes. The point that I asked earlier about this High Court verdict on the case with Suleiman Abrahama's group, the Media Foundation, and of course, I think there's another MP
and it's not going against the Electoral Commission.
I mean, these two cases, aren't there precedent then that raises these fundamental questions, and people will cite to that and say, well, that is the law that exists now, and so that's what we are going to use. And how does that fundamentally affect enjoyment of this right?
No, so I think it's important for us to get the judgment, because we have to understand the reasoning. There are a couple of things in the, at least from the reporting, that for me will be very, very interesting to understand the logic of the High Court. For example, in determining whether something is a matter of public interest or not, in determining whether or not a fee is reasonable. We need to understand the logic so that then you can think of the jurisprudence of it. But at the moment, as has been stated here, it's a complete, the reasoning for trying to fix the price at 1,500 and so on, it's completely inconsistent with the law, because you read section 75, it's very clear that you cannot, if indeed the NCA case, for example, was that the person or the argument was that they needed to do research. That means they are talking about time, payment for time. And it is very, very clear in section 75 that you do not make payment or impose a fee for time spent in preparing the information. So that is, on the face of it, that is not even, it's a non-starter. So it does say that we need to definitely engage the judiciary so that they can also fully appreciate the law, and so that it's going to affect the judgments that they put out. So it will be good definitely to look at the judgment, because that would then...
I think I may have lost him again. But I want to quickly bring in the Dr. Winifred Nafisa Mahama. She is the head Access to Information Division at the Information Services Department, of course, Information Ministry. Doc, explain to me, where are the information officers? Are we learning very shocking revelations about requests made under the Right Information Law? Ministries are saying if you don't address it to the minister, we are not going to respond to it. What's happening? Why are we having that?
Good evening, and thank you for having me. It's quite unfortunate we are having that because the law clearly states who the request should be addressed to and who should see through the processing of the request. In implementing policies, it goes through a particular process. Institutional reforms doesn't change overnight. We've gone through a process where institutions like the public sector previously handles issues in a particular way. Institutional change and change management in addressing issues takes quite some time. We don't expect it to take long. They know that the law spells out the process and procedure for processing requests for information under the RTI law, and it is clearly spelled out. The Honorable St. George quoted the law, the section that says that. And Manasseh has also said clearly that this is not an issue across board. It is a few institutions that they encountered that majority of them go through the processes that has been outlined here. We have started implementation over a year now because due to the moratorium. So the implementation started 2nd January and moving forward. So as we move along and implementing, once the Allied Council clarifies certain gray areas and we move along, we know that all these hurdles will be tackled as we move along.
When is the timeline for the LI going to Parliament? The LI that will spell out the fees and charges and also straighten some of the rough edges that we're beginning to learn of?
Now, the request or the proposal for fees and charges has been already submitted to the Ministry of Finance, and we know that it's been prepared to be included in the next fees and charges scheduled to be approved by Parliament. But in lieu of that, the Commission issued a circular guiding institutions on pricing and charging information. And so there is something on the table that guides them. And the Act in Section 75 also spells out the process, the fees and charges guideline that the institution should undertake. Okay, in lieu of that, most of the institutions even grant the information without even charging, and others also charge the market price for photocopying and all that. And Manasseh has alluded to that from other institutions. So we have most people going by 75 and others also going outside the law. And once the law is being tested, which is good for Ghana because it's a new law, we are all trying to work towards ensuring that information is provided, access is provided to everybody, everywhere, which is under the Constitution and under this Act. So once we go through the implementation, we get through these hurdles, the law is tested, we correct, we move on. Over time, everything will iron out.
Manasseh, you had an intervention.
Yes, I think that what she's saying is right, but it is becoming clear that a trend is being established. It appears that if the state institution suspects that the information you are seeking as a journalist is to expose some wrongdoing, they will frustrate you. There are certain institutions we've applied to that the information there wasn't any suspicion of any incriminating evidence or information to use for anything. We didn't have any difficulty. But I'm beginning to suspect that from the trend we have had, and we at the Fourth Estate have done a number of requests, have made a number of requests. Some of them, or I can say almost all the places that the people suspect that this information is going to come out and put us in a bad light, they find reasons to frustrate. If you look at the Media Foundation for West Africa's request to the NCA, I think Ghanaians should be worried because a state institution did something that can be considered fraudulent. You posted a report, the second quarter report of 2020. And so the Media Foundation went through your website and said, look, the reason you give for the closure of these radio stations is that they have not renewed their frequency authorization for a number of periods. But from your own data, we have found A, B, C, E, D, E, and others that are also in the same soup. So can you explain to us, the next moment, the NCA pulls down this report from its website, deletes the two columns that indicates when the radio station was first given authorization and when it was last renewed, deleted those two important columns and put them back there. So if you go to the website of the NCA now, you realize that the 2020 second quarter report, the format is different from all the rest. And so if the Media Foundation for West Africa is asking for the original list and an explanation as to why they deleted it, they suspect or they know that they are going to be exposed. And so all what they are doing is to stop being exposed. And that is the impression I'm getting from a lot of the institutions that we are finding it difficult to get information.
Yeah, I mean, and it begs the question, I think it's George who touched on it. Doesn't the Freedom of Information Law as it stands now lend itself actually emboldening state agencies use a legal means now to evade exposure? And will the LI fix that? How does the LI begin to fix that? We'll attack that when we return from the short break. That's on PM Express. Let me introduce you some, George. So, I mean, we've heard a lot. There's a lot of, I hear a lot of people, there's a suggestion that the LIs that are coming might fix some of the problems. You have as much faith in that?
Absolutely not. The law is clear. I mean, and with great respect to Dr. Nafisa Mahama, I mean, when I hear her talk about grey areas fixing some of the issues, there is no grey area about who handles a request. The law is clear. It must be an information officer, Section 19. Again, it is clear in Section 75 that you don't charge anyone for time spent in putting together a report. You don't need an LI to clarify this. This is in black and white. What we need is proper enforcement of the law, proper structures to implement the law. The LI will not put in place structures. The commission, it is the responsibility of the RTI Commission to put in place the structures. It is the responsibility of the RTI Commission to ensure that institutions of state, public institutions, comply with the letter and spirit of the law. It is the responsibility of the Commission and the Ministry of Information to ensure that the judiciary is well trained to interpret the law and understand that the law is not 1,500 Ghana cedi law. So you see, these are not grey areas that will be fixed by the LI. What you need is a proper implementation of the law.
I mean,
with sanctions for agencies of state that will flout the letter and spirit of the law.
I mean, Dr. Mama, final word to you on going forward in terms of fixing some of the challenges that have been addressed. What's the ministry's plan to resolve these issues? Very briefly.
The commission is there to enforce the law. The commission has been inaugurated and is working. We know that as we're moving along, that will be fixed along the line. But just a quick one. You know, the law mandates that the Minister of Information presents an annual report to Parliament. And the Honorable Sam George made note of it. In the coming week, the Minister will be presenting that annual report detailing what has transpired from 2nd January when the law became effective to 31st December. I'm sure that once we move along, we see that certain institutional frameworks and structures have already been put in place to ensure smooth implementation of the law within public sector institutions. And the commission has been set up to ensure that the public service information, public institutions are compliant with the law. The law also spells out appeal processes.
Yeah.
So once an applicant is satisfied, it spells out a 3-step appeal process.
Yeah, I mean, ending all the way at the court, which has been tested already, and we've seen the outcome of that. But the Information Minister, I understand, is coming to Parliament next week to give that reporting, so we'll wait for that. But meanwhile, just before we've been talking, Dr. Poku Edusei, who is the legal officer at the NCA, has this to say. He says, "I followed the narratives of Brahma and Co, and I wish to state that they have," he says, "misunderstood the judgment. Besides the fact that some of the questions of Media Foundation were deemed not to be requests for info, other access to the request cover 730 plus TV radio stations. In terms of station license, NCA and the list of TV radio stations are published online. Media Foundation expects the entire list juxtaposed with the exercise of the regulatory mandate of NCA vis-a-vis the 2017 Spectrum audit." In response to Sam George, he says judges cannot abdicate responsibility when a matter is presented and defer to another branch of government. Judges, upon assumption of jurisdiction over a matter, must bring finality to it and cannot send parties away. I mean, we will see how this pans out in Parliament. Sam George will get to grill the minister next week when he comes. Enjoy the rest of your evening.